Yes. So today is the day two. On day two, we are now beginning our journey into the structure of private family trust. So today we are going to be discussing very core of private family trust, starting with the Indian Trust Act. Then we will move on to certain key aspects of a trust deed. And finally, there is a very important document when we discuss about private family trust, which is called as the letter of wishes. So I'll be discussing certain key aspects around that. Yeah. So our today's agenda is going to be in six different steps. At the first place, we will be discussing as to why we are going to be, why we discuss will just for one day, and now we are going to be discussing private family trust for the next 6 to 7 days. So why, private family trust scores as a better tool for succession planning as compared to all other tools. We'll be discussing that. Then, there are quite a few common myths around the structure of private family trust. So we will try and address those myths and understand what is the ground reality. Then we will move on to understand the legal landscape of a private family trust, the way we had understood for succession planning. Here I'll highlight which all laws you need to consider and have a broad index of whenever you are planning to set up a private family trust. Then we will move on to all the important provisions of Indian Trust Act. I have selectively identified certain important provisions which I felt would be quite important for each one of you to understand. So we will be discussing the entire legal landscape around the private family trust. The important provisions of the Indian Trust Act. Then we will move on to the instrument of trust or the trust deed. We will see how the law defines the trust deed to be and a couple of key parameters around that. And lastly, we will be discussing about the letter of wishes and what is the importance of letter of wishes, what role does it play, and how the Indian landscape looks at it. Yeah. So with this, let me directly jump into the first point, which is how does a private family trust fare against the objectives? So in our Friday's webinar, we had discussed what are the objectives that one has to consider while planning for succession planning. So we had divided that into broadly two categories. One were emotional objectives and other were financial objectives. So private family trust is a tool which has a green tick for both the objectives. And that is the reason why it is considered as a sophisticated and the most preferred structure for succession planning. So what were those objectives is, first, if say I am the person who wants to plan for my wealth succession. So first I wanted that the succession should happen as per my desires. So private family trust, if I am setting up during my lifetime, I can set it up during my lifetime. I can set it up after my lifetime also as part of the will. So if I'm doing it during my lifetime, then I'll be able to decide on what proportion to go to him, when to go. So my entire succession happens as per my desires. Next is, since I'm able to do it during my lifetime, to a lot of extent I'll be able to avoid potential family conflicts which otherwise are quite common whenever there is an intestate succession. In other words, there is a succession where there was neither a will nor a trust, nothing in place, so the succession happened as per law. Yeah. So private family trust helps me achieve both these emotional objectives. On the financial objective side also, for ring fencing of my wealth and for protection against estate duty as and when if it would be introduced in India, if I carefully plan and structure design my private family trust in the right way, then I can even achieve the financial objectives as well. And lastly, a private family trust is a globally recognized structure. So almost all the countries of the world recognize trust, and it's quite common structure as far as succession planning is concerned. So if you have a private family trust set up in India or in any other country where you have multiple assets situated under that trust which belong to different jurisdictions, then at least you would not face the issue of the structure itself not getting recognized in that overseas country. Yeah, because trust is quite common and widely accepted concept. So that is why, since because of this merits, PFT is considered as a quite a superior tool for succession planning. Yeah. Now coming to general myths around private family trust. So the most common myth which I generally hear about or discuss about is, everyone considers private family trust as a person, okay, Why do they consider this as a person? Because it has its own PAN. Okay, so whenever you form a trust, you can apply to a income tax department, and income tax department will give you a distinct PAN for the trust. Okay, so what people believe is as soon as the PAN is received, now this is a separate person. This is the biggest myth. Okay, trust is not a separate person per se. What it is, we'll just see in a while. But person meaning, say I as an individual, I am a person. If we have an LLP, LLP is a different person, company is a different person. So there are different categories which have been recognized as person. As a matter of fact, even HUF has been recognized as a person under the income tax laws. But trust has never been recognized as a person under any law, not just in India, even globally. Yeah, with Dubai being a kind of an exception with their foundation structure, but will not complicate that. Foundation is slightly different than a trust, but as far as trust is concerned, it is generally never a person. Okay, so even though it has a PAN, that doesn't mean it becomes a person. PAN has just been given to it for administrative sake and for ensuring that the trustee's own PAN doesn't get merged with the PAN of the trust. So for that administration part, that the trustee can keep a distinction between his personal affairs and the affairs of the trust. That is the reason PAN has been allocated to a trust. Okay. Next, what I usually hear is that people feel it is a distinct entity. Why? Because it has its own bank account. See, generally speaking, a trust will never have any asset in which it would be written that the owner is the trust. Okay. In case of a trust, the trustee is always the legal owner and beneficiary is the beneficial owner. In our Wednesday seminar, we are going to be diving deep into this topic of, what ownership lies with trustee, what ownership lies with beneficiary. But for now, let us understand that the legal ownership is in the name of the trustee. So any kind of asset that goes in the trust, ideally the trustee's name should be mentioned on the title of that particular letter as the legal owner of that asset. Now, bank accounts is the only exception. Generally speaking, if all other assets, like say you consider demat account, you consider immovable property, everywhere the name of the trustee would be inscribed as the owner. It is just that the bank account, whenever you open for a trust, on the website, on the bank statement, name of the trust is mentioned. Now, a couple of banks have started modifying and updating that practice to bring in the trustee's name. That is the right practice. But still, there are many banks who still open bank account in the name of the trust. So, that again creates a common myth that since it has a bank account, it's a separate entity. But one thing is very clear, trust is not having its own bank account. It is the trustee who is owning the bank account. Okay, so someone would ask a question, then what is a trust? Okay, so trust is nothing but an obligation. Okay, and in very layman terms, you can say that it is merely a contract. Now, how does that happen is, so let us see section 3 of the Indian Trust Act that defines the trust. How they have defined it is, a trust is an obligation. Here in the act itself, they have defined that to be an obligation. In simple terms, obligation can be considered as a responsibility. Okay, a trust is an obligation annexed to the ownership of the property. So there is a responsibility attached to the ownership of a property. How does that responsibility arise? So it arises out of confidence reposed in and accepted by the owner. So what happens is, whenever a trust is getting born, there is a settler, he has an asset. He says that there is a responsibility attached to this asset which I am giving to you. You is the trustee. And the trustee says that, okay, I am accepting the asset along with the responsibility, and I assure you that I will fulfill this responsibility which you are giving to me. Okay, so this exchange of responsibilities, so giving of responsibility and accepting it, on the trustee side, assuring the settler that I will fulfill the responsibility, and the settler getting satisfied with your assurance. This is the kind of exchange that is happening when a trust is getting born. And this particular exchange, which has quid pro quo attached to it, is nothing but a simple contract. So if anyone asks you what is a trust, trust is not a person, it is not an entity, it is not even a structure, which I was also currently using in my speech. It is not even a structure, it is a simple contract. Contract for what? Contract for exchange of trust, faith, confidence and obligation between settler and the trustee. Yeah. So this is the biggest myth which we have to keep in mind, is that whenever we are interacting or looking at a trust deed, we have to understand that this is not a structure. So always you have to go one layer deep to understand who the key constituents are, who the beneficiaries is, settler is, trustees. Only then you will understand the gamut. Because many a time what happens is that I have seen people just seeing that okay, we are doing transaction with a trust, and they forget to see what the trust, I mean what the contract underlying says. So it's very wrong to say that you are doing transaction with the trust. The correct thing would be that whenever trust structure comes up, go through the deed and understand what is the real arrangement beneath that for which the contract has been executed. Yeah. So this was a common myth which I wanted to highlight around the trust part. Now moving to the next part, this is a bit important because this will help you build your entire index for whenever you are looking at the trust structure or trying to develop one, what are the kind of laws that you have to go through. Okay. So first and foremost, I always recommend to everyone that you have to see Indian Trust Act 1882. This is the most neglected act, not just by say non-finance professionals, but I've seen many CAs and lawyers also not giving that kind of an appreciation to this particular law. What happens is that whenever there is a trust part, we CAs always like discussions around income tax. So we directly jump to point number 2 and only discuss about the tax implications arising in that case. And we design the entire trust structure also keeping only Income Tax Act in mind. So no disrespect to this particular law, we have to respect the Income Tax Act. But before going over here, or at least if you're giving this a priority, before you finalize the trust deed, you have to understand that your trust deed has to abide by all the provisions of the Indian Trust Act. Okay, if the Indian Trust Act, there are now in the subsequent slides I'll highlight certain provisions which you guys would also be quite surprised to know that in those provisions it's quite clearly mentioned that in the Indian Trust Act, if you are not fulfilling certain provisions, then your entire trust can become void ab initio. The trust itself can get settled in the court for its validity itself. So it becomes quite serious. So Indian Trust Act has to be given quite a big importance, and that's the main agenda for today's discussion. Then comes your Income Tax Act. In a cross-border situation, FEMA also becomes extremely important. Our last webinar series is dedicated for cross-border trust, where we'll be discussing FEMA part in more detail. But just as an introduction part, what does cross-border would mean is that say a couple of your family members are outside India, a couple of them are in India, or your assets are also divided between two countries. So in such a case, if you are planning to set up a private family trust, then for your members as well as the assets that are outside India, or a flip situation, FEMA would come into play, because now two countries are getting involved and the exchange regulations of each of those countries have to be respected. Yeah. Then you have to give importance to Stamp Duty Act as well, because any kind of a trust involves transfer of property from the settler to the trustee. So there could be certain stamp duty implications. Registration Act is the act under which your trust deed gets registered. So knowledge of Registration Act is also quite important. Then comes the Transfer of Property Act. Many people will wonder, why have I considered TOPA over here? But trust me, Transfer of Property Act is quite important as far as private family trust is also concerned. Because these days I have seen many professionals telling their clients that once you settle a trust, it can be a perpetual structure. It's a very wrong statement to make. Okay, under the Transfer of Property Act, the Indian government has categorically stated that you cannot have a perpetual transfer, which means what? The asset has gone from your hands, it is in a conduit pipe, in a structure in between, say like a trust, and it is not going to the final beneficiaries. So there is a time limit to which you can keep the assets in the conduit pipe. You cannot keep it in a perpetual way. So if you come across a trust deed which actually has this statement that this particular trust, this trust life is going to be perpetual, it's void. Consider that to be void ab initio. So it's very important that your trust deed has to follow all the provisions of Transfer of Property Act. Okay. Then there are going to be transaction specific or asset specific laws like Companies Act, LLP Act. Like say if your trust wants to hold shares, Companies Act would be important. If your trust wants to become partner in another LLP or a firm, then LLP Act or Partnership Act becomes important. If say there is a promoter family, they want to settle their promoter holding into a trust, then even SEBI takeover code and those kind of laws become applicable. So this is a broad framework of how you have to traverse the legal landscape as far as the private family trust is concerned. Yeah. In the Q&A part, there is very interesting situation around the Transfer of Property Act and how a trust can become void by that. Okay, if someone would be interested, then just drop in a Q&A. We'll cover it at that point of time. Yeah, now I'm beginning with the discussion around the Indian Trust Act, certain important provisions around that. So first and foremost, the most important thing is the preamble of the Indian Trust Act. It says an act to define and amend the law relating to private trust. Okay, the private trust is extremely important. So Indian Trust Act 1882 does not apply to any charitable trust or religious institutions which are called as public trust. What is the difference between private and public is, in a private trust, your beneficiaries are a defined set of people and those are identified. In a public trust, you are making public at large as the beneficiary. So whosoever wants to seek help, they can come and take help from you. Okay, you are just defining the objectives. So all the charitable institutions, religious trusts, all of them fall under public trust. Here we are dealing with, since we are on the topic of succession planning, we are dealing with a private family trust. And that is why a private trust becomes a private family. The preamble clearly says that for private trust, only Indian Trust Act 1882 applies. It doesn't apply to any other trust. Then there is a saving clause which is very important. First we'll read it and then I'll give you a background. Nothing herein contained affects rules of Mohammedan law as to waqf. Okay. Now, in the first webinar, I had suggested, I had stated that there are certain religions, like say Muslim religion, where the Sharia law says that you do not have your own right to pass on the wealth as per your desires. The wealth has to pass on as per the process stated in the Sharia law or whichever Mohammedan law that applies to you. Okay. Then we had discussed that for Muslims, if they still want to go ahead with controlled succession as per their desires, they have the option to set up a private family trust during their lifetime. It has to be irrevocable in nature, settle assets into that and then you define that. So it's acceptable and everything is done. Now, many a times we receive the query that, ये saving clause जो है, this clearly states that nothing contained in this law is going to apply to Mohammedan law. And then they say that means Muslims are not allowed to set up trust. That is not the right reading. See, the section says nothing herein contained affects rules of Mohammedan law as to. The terminology S2 is very important. S2 waqf. So the provisions only pertaining to waqf, to them Indian Trust Act doesn't apply. But generally speaking, if you are not in that waqf related issues or the kind of topics, then there is no restriction even under the Mohammedan law for this particular part. So I wanted to highlight that even Muslim families can still settle PFTs during their lifetime. This saving clause doesn't affect them. Yeah. Then going to section 8, which is again a very, very important section. What it says is that it talks about the subject matter of the trust. So the subject matter must be property which is transferable to the beneficiary. So, if say for example, I am a settler, I am telling a trustee that you have to take care of my kids. Okay. And the trustee is saying, okay, I'll take care of your kids. This is not a trust. Okay. For taking care of my kids, I have to give some property to the trustee. So a certain tangible property has to move from the settler to the trustee, and the trustee should agree to take care of that property for the benefit of the beneficiaries. Okay. So if there is no property that can be transferable, then the subject matter of the trust is absent and then the trust cannot be formed. Okay. Now see the second line, which is extremely important. Must not be merely beneficial interest under a subsisting trust. Now this is extremely important. Okay, you all would have seen many structures where people these days are making a hierarchy. There is a main trust which is called as a parent trust. Then there are parent trust or a master trust, and then there are sub trusts below that. So in complex cases, we do have such series of trust and structures where there are multiple trusts for achieving your succession plan. But here it's very clear that in section 3, it should not be merely a beneficial interest under a subsisting trust. So say if you are forming a trust structure where you are breaching this condition, wherein say there is a trust, the only property in that trust is beneficial interest in another trust. Such a trust is going to breach section 8 and the trust would be treated as void ab initio. There are ways to circumvent that, but you have to plan properly. So I've actually seen certain trust deeds which were breaching this particular section. Okay. Now what happens, income tax mein kaisa hai? You keep on getting scrutinies, enquiries and those things. So there is a health check and a recurring rectification exercise that can go on. Indian Trust Act is a rather passive law. So unless and until you are before a court and someone is validating whether the trust was right or no, there is no one who is going to come and tell you that the trust was wrong. So most probably at the time when you are not around and now your beneficiaries actually want the assets from the trust and some issues arise at that stage, that time it will go to the court, and if this particular section would have not been followed, then there are chances that your trust becomes void ab initio. So it's a serious thing. So very important to take care of section 8. Okay. Then it's about section 11, trustee to execute trust. So here it says trustee is bound to fulfill the purpose of the trust and obey directions of the author except as modified by the consent of all beneficiaries. So when does section 11 play importance is during the life cycle of the trust, there will be several instances where one would have to edit the trust deed, amend the trust deed. The trustees might want to do that. So I've actually seen that many trustees amend the trust deed and they forget about this particular provision, section 11, which tells that before such amendment, the trustee has to take consent of all the beneficiaries. It has to be a unanimous consent. So that is why I wanted to highlight this over here, that section 11 is often missed. So whenever you are amending the trust deed, please make sure that you have a written consent from all the beneficiaries on record so that no one raises questions in future. Okay. Then another important section which I wanted to highlight of Indian Trust Act is section 58, which gives the right to the beneficiary to transfer the beneficiary interest. It says the beneficiary, if competent, may transfer his interest subject to the law in force. Okay. So here generally a question arises is, what about a discretionary trust? So in a discretionary trust, we'll be studying in the next on Friday about discretionary trust. But in discretionary trust, generally there are beneficiaries, but they don't know what we are going to get because the trustees have not exercised the discretion. In future, the trustees will decide what to go to whom. So if there are 3 beneficiaries, there are chances that one of them might receive everything. There are chances that he might not receive anything. Any possibility is fine. Now in that case, where nothing has been received by you, you don't even know how much you are going to be received. It is not quantified. Can you still use section 58 to transfer your beneficial interest? The answer is yes. See, this section is not on quantification part. Do you have a right in the trust? Yes. You have right in the trust, but it is not quantified. So if it is not quantified, it is absolutely fine, but you still have that right. So your unquantified right also you can transfer to some other person by using the benefit of section 8. Okay. And yeah, this is quite important also while drafting your trust deed. Please ensure that when you transfer the trust deed, it should not defeat the provision of section 58. Okay. Then coming to section 60. Section 60 is all about trustees. Who is a proper trustee and not. There are interesting explanations to section 60. See, the first explanation 1 to section 60, it says a person that is domiciled abroad is not a proper person to be appointed as a trustee. See, it's very, very important. There will be so many trusts where you see non-residents forming who are becoming trustees in the trust. But explanation 1 to section 60 clearly states a person who is domiciled abroad is not a proper person to be appointed as a trustee. Okay. Now, exception to that is definitely. So, Indian Trust Act is beautiful act. What it says is that the law is there, but if the settler trustee between themselves, they want to expressly override any provision of the law, to some extent that kind of flexibility is allowed. So practically what everyone does is, if you want to appoint a non-resident trustee, my extremely strong recommendation would be that if you are planning to do that, give specific overriding reference in the trust deed. State that as per explanation 1 to section 60, though a foreign domiciled person is not considered as a deemed person to be a trustee, but considering our family dynamics and based on discussion between the settler and the trustee, we feel that this non-resident person is the best suited person to act as trustee in our fact pattern. You have to draft it legally, but this has to be a gist. So please keep this in mind and do that. Also, important thing is, note that here the term that is used is domicile and not residential status. Last time we had discussed briefly about domicile and how it is different than the residential status. So here you have to bear in mind that this particular act also refers to domicile of the person and not its residential status. Okay. Then again, a very important explanation frequently missed in a lot of trust deed. It clearly states that where trust involves receipt and custody of money, minimum 2 trustees are required. Okay, I've seen so many trust deeds where obviously on settlement the first thing that goes is the transfer of a bank balance. So this particular requirement triggers, but the trust deed only has 1 trustee appointed in that. Now that defies the applicability of section 60. So such kind of missing such kind of loopholes are exposing your trust to get treated as void and thereby getting challenged in the court. So whenever there is custody of money, minimum 2 trustees are required. Now if you have a corporate trustee in place, then this requirement automatically gets settled, because corporate trustee will generally either be a LLP or a private limited, and both of them have requirement that they need to have at least 2 partners. LLP needs to have at least 2 partners, and a private limited needs to have at least 2 shareholders and at least 2 directors. So in that case also your 2Ka requirement will be fulfilled if it's a corporate trustee. But if you are appointing any individual as a trustee, please keep this in mind. You have to appoint 2 persons. Lastly, I wanted to highlight something around the revocation of trust, but we might not have a lot of time for that. So one key pointer for that is revocability of a trust or a revocable trust. How the Indian Trust Act looks at it vis-a-vis how the income tax looks at it is dramatically different. Yes, so there can actually be a situation where a trust is revocable as per income tax, but it is irrevocable as per section 78 of the Indian Trust Act. So while drafting a revocable trust or an irrevocable trust, which is going to have this thin line, it is extremely important to ensure that your wordings in the trust deed are correct to not lead to any confusion, because revocability is an angle which creates a lot of havoc if not planned in the right way. Okay. So on my LinkedIn page, I have written a very detailed article explaining section 78 and how a revocable trust takes birth as per the Indian Trust Act. It is there on my LinkedIn page. It's also there on our firm's website. You can please feel free to go over there and read. If you have any queries in the next webinar, please raise queries around that. I'll be happy to answer. Great. Now moving to the instrument of trust, we have covered the important provisions of the Indian Trust Act or the trust deed. It is defined under section 3, which says that and the instrument, if any, by which the trust is declared is called the instrument of trust. See, the beauty over here is if any. So the Indian Trust Act by itself is not taking it mandatory that you need to have a written trust deed in place. Okay. If any indicates that even oral trusts are respected per se. But obviously oral trust face a lot of practical difficulties, so we never recommend anyone to go for oral trust. Have a trust deed per se. But if someone asks you, then the statutory position is that having a trust deed is not mandatory. Okay. Then registration. It is also defined under section 3 that registered means registered under the law of registration of documents for the time being in force. Because many people tell us, please register our trust deed under the Indian Trust Act, and we have to tell them कि भाई Indian Trust Act में registration का powers ही नहीं है. There are no powers to register a trust under the Indian Trust Act. Okay, you have prepared a trust deed. If you want to get it registered, there is a Registrations Act in India. You go under that act and get your document registered. So here what is getting registered is there is going to be a registrar who is sitting over there. He's taking your agreement, scanning it, keeping it on official record. That's the limited purpose of registration. Your contents of the deed are also not verified, nothing is done. So if say someone tells you KR in drafting of trust deed, Dhruv was saying that there are so many issues, so many people miss around Indian Trust Act. So what if let us draft it, we'll get it registered even though it is voluntary in nature, and if the registration happens, that means our trust deed is valid. No, that's a big myth. Registration of a trust deed is not a proof that your trust is valid or no. Okay, it is merely that your trust deed is now registered, so the genuineness of the trust deed increases. No one can challenge the trust deed. That's the only limited purpose of registration. Also, what I've heard, frequently hear about is that if I'm doing registration, then my trust takes birth. It takes form of an entity. So if I have unregistered trust, that is not a person, but a registered trust becomes person. Again, this is a myth. So registration is not equal to formation. Registration is not akin to incorporation. Like for LLP and company, when you get certificate of incorporation for both of them, that's a very different process where the entity is taking birth. Here the registration is not at all linked to that. It is a mere registration of the document. Then talking about the confidentiality part, how is the confidentiality of the trust deed before the regulators? So it's not, you cannot keep it confidential. The regulators can demand you to submit the trust deed. Even bankers, your demat guys, many people can demand you to submit the trust deed to verify the disclosures that you are making. So it's not that confidential. Before the beneficiaries, okay, this is a good point. So for beneficiaries, there are a couple of stages, okay. When the settlement is happening, when the trust is getting born, it's an agreement which we saw, right? It's a contract between the settler and the trustee, and that contract is written in form of the trust deed. So this is only to be kept between the settler and the trustee. The beneficiary doesn't have any right to demand the copy of the trust deed. Okay. Now, in a situation where the settler is nowhere around, okay, in that case, it becomes the liability and onus of the trustee to inform the beneficiaries about the existence of the trust. At that time, the beneficiaries may demand the deed. Why? Because now the beneficiaries have an enforceable right against the trustee. To enforce that right, they can demand the copy of the trust deed. So as far as beneficiaries are concerned, consider that way that during the lifetime of the settler, even if the beneficiaries do not receive the copy of the trust deed, it's perfectly fine. You can keep it confidential before all the beneficiaries. That's good also, because you would not want your kids to, at this point of time, maybe not have a look at what you had planned for them. So you can keep it confidential. After you are not around, then it's a good practice to show them. Now coming to the last part, for the letter of wishes. This is a very, very important document. Okay, since the trust deed is to be submitted to so many regulators and places, there could be things which you might not want to put in the trust deed. Or there could be some situations where after you are not there, the trust deed might even come in the hands of the beneficiaries. So you might not want to show something to the beneficiaries as well. That is where letter of wishes is a very good concept that comes into play. Okay. I have seen letter of wishes where settlers have put in such a good emotional description also, that how our family situation is today, which beneficiary is behaving, how is their personality trait, how is the relationship between the beneficiaries. So a lot of emotionals and actual facts are put in the letter of wishes. This helps the trustee understand the real family dynamics. And then the settler states that, what are my desires, wishes for this particular family. Then he can also foresee certain situations that in future, if say so and so beneficiary is not behaving well, what I would want you to do. If he is behaving well, what I would want you to do. Maybe one beneficiary could be slightly weak, who might need more support. So what kind of support you can give him? Someone could be stronger, not needing much support. Someone is cooperative, someone is not cooperative. So a lot of emotional aspects you can cover in part of the letter of wishes. And what is that? It's a simple letter from the settler to the trustee. Okay. What is the purpose is this particular document, because of all these emotional issues, if it is well articulated and written in the letter, then it acts as a superb guiding force in dilemmatic situations. Or in future, whenever say the trustee would want to decide how much to make the distribution, he's stuck somewhere, then he can see this letter and recollect the family dynamics and then decide in the best possible way. So it has a very strong purpose. Legal standing, it doesn't have any legal power. So the Indian Trust Act or any other law for the time being in force doesn't recognize letter of wishes in any way. However, if there are any situations before the court where the trust deed is getting challenged or decision of the trustee is getting challenged, and the question comes up on identification of what was the settler's desire, because what is the trustee doing? The trustee is fulfilling the settler's desire. Yeah, that is his core responsibility. So the question will come around desire. At that point of time, if the trustee is presenting the letter of wishes to the court, then a lot of clarity can come up. So the courts will respect the letter of wishes to understand and develop the desires of the settler. Yeah, so that's how the legal standing part comes. And lastly, on terms of confidentiality, so before the regulators, extremely confidential. No regulator can ever demand you to submit the letter of wishes, except for when you are in the court and the court is asking for that and the trustee is agreeing to give that. Otherwise, the regulators cannot demand. In fact, your trust deed did not even refer to the letter of wishes. You can keep both the documents independent also. For the beneficiaries, again, extremely confidential. A beneficiary under no law or any statutory right can demand the copy of letter of wishes. So letter of wishes is extremely confidential. So you can put in a lot of details over here. Yeah, so I think with this we have ended my presentation for today. Hope it was good. Looking forward to see you, all of you guys, on Wednesday for the webinar 3, where we are going to be discussing in detail about settler, beneficiary, trustee and the protector. This is one of the most important discussions. Again, I'll be bringing out a lot of issues around this thing, all 4 of them. So now I'll just take a minute and stop the recording, and then we'll open up